Yes. I just got here about 4 minutes ago. And, I was looking at these personal recognizance. Yes. I had one of these for violating the no contact order. Yes. City of Swim was a plaintiff, and then for some reason you misspelled my name. Instead of Budnick, it's really Nek. Yeah. Now, the court, having determined that personal recognizance will not reasonably assure the presence of the defendant when required, or that the defendant may be a danger to the community, imposes the following conditions of release. Bail is hereby set at personal recognizance. Now, I know that having determined that personal recognizance would not reasonably assure my presence as a defendant when required, when you set the bail at personal recognizance, doesn't that kind of defeat the whole statement that the court, having determined, yes, that personal recognizance would not reasonably assure the presence of the defendant when required, or that the defendant may be a danger to the community, imposes the following conditions of release? Yes. Now, bail is hereby set in the amount of personal recognizance. Let me just read this in the District Court of the State of Washington, McLeod County. Order for release and conditions. It is ordered that the above named defendant be released from custody on the following conditions. Yeah. Um, Personal recognizance. Yeah. Now, I know that Judge Porter's probably filled out thousands of these. Yes. And there's a reason why you say you don't think that I can reasonably assured to appear in court. When at the same time you did think I could reasonably assured to appear in court. Somewhat confusing for the individual that's on personal recognizance. Ouch. Now, did anybody help the court to understand how these forms work and exactly what boxes you should be marking when you as a judge have an individual that you've decided that you're going to release myself, but I'm a danger to the community? Yes. Does the state of Washington actually explain these different forms, or have you ever looked at them before? Because marking that box, the court determined that person will not reasonably assure, yes, my presence as a defendant when required, or that the defendant may be a danger to the community, impose the following conditions of release. Now, it does say defendant shall not violate the criminal laws, nor the traffic laws, nor drive a vehicle unless properly licensed and insured. Yes. And you would think that that would be kind of an understood. I mean, how many times can you tell a defendant, well, I think you should violate the criminal law? It's one of those you thought you should tell the defendant. It's interesting how they have this worded. Now, this says a defendant shall have no contact with Heidi Budnick. Yes. As if a protection order wasn't enough. I needed to be on personal cognizance and how it'd be a no contact order. That's fine. That's fine. A defendant shall contact court ordered appointed counsel within 48 hours. Yes. And then defendant shall maintain his or her current address, not change it. And then do not use email to communicate with Heidi Budnick or any other protected party? Yes. Now, this was signed on the 5th day of January of 2016. Look at it, says, do not have any contact with Heidi Budnick. Yes. Now, you would have thought they did the same thing on Guam when I go.